The very first juries, impanelled to assist William the Conqueror in the compilation of the Domesday Book, were a mechanism to ensure efficient tax collection and to ensure that local farmers were not hiding cows or crops from the king. Very well for the king. These juries were not meant to be impartial auditors of proceedings with no background knowledge and no existing views of those appearing before them. They were impanelled precisely because they did know the locals and who was likely to be telling the truth. And their role was to understand local languages and customs and often to translate for the king and his Norman officials. In the 12th century, when the administration of justice began to be centralised into the king's courts, which would dispense a justice common to all throughout the kingdom, a significant problem arose. The legal solutions to common problems might be common throughout the land, but the law of evidence had not yet been developed to a point where efficient methods of testing the facts to which these legal solutions would be applied had come into existence. So the jury of the Domesday Book took on a new life. For every case heard in the King's Court at Westminster, a local jury would be required to attend by a writ, issued by the King's representative, the Shire Reeve or Sheriff. The jury was not meant to be impartial and come fresh to the matter. Their role was to understand the facts of the case before they attended the court and help the court to determine who was telling the truth, not based on a sophisticated system of cross-examination, but on what they knew of the veracity and the background of the litigants appearing before the bench. By the 13th century, the jury was fixed at our familiar 12, all of course men, and by the 16th century, the jury takes on a more modern character, with jurors no longer being asked to decide cases based on their own knowledge, but rather only on the basis of the information they receive in court. This style of jury continues to this day. We may no longer require a priest to be a member of every jury, and we now expect jurors only to be guided by what they hear in court and not to make their own inquiries about the matters presented to them. If they know the litigants, they are now ineligible to serve as jurors on that case. But their role is just as critical to the operation of the justice system as it has always been. It is the jury which is the arbiter of fact and decides what has actually happened in the matter. Juries are still the familiar 12 in criminal matters. Majority verdicts are now permitted in certain circumstances, but the jury is still, as far as practicable, designed to be the jury of one's peers, insisted upon in the Magna Carta. In fact, it was this very requirement which delayed the introduction of the jury trial into New South Wales for so long, because the squattocracy were convinced that the freed convicts could never form a jury of their peers, so they kept blocking the notion of the jury. As Blackstone in his commentaries observed of the importance of the jury system, a competent member of sensible and upright jurymen chosen by lot from among those of the middle rank will be found the best investigators of truth and the surest guardians of public justice. For the most powerful individual in the state will be cautious of committing any flagrant invasion of another's right when he knows that the fact of his oppression must be examined and decided by 12 indifferent men. Trial by jury was a demand in Magna Carta, and its absence a justification for the revolt of the 13 US colonies and the Declaration of Independence. It is a fundamental pillar of the rule of law and of our common law system, and should not be subject to change without careful consideration. But as this survey of the development of the jury indicates, it has changed over the years, and it is appropriate to consider sensible change to help juries operate more efficiently. To the extent that the Jury Amendment Bill seeks to improve the efficiency of jury empanelment and its operation, the opposition is happy to support it. Many of the proposed amendments derive from the review of indictable processes led by the then Chief Judge of the District Court, the Honourable Derek Price. These changes will enhance support for jurors and reduce the likelihood of aborted trials and hung juries. They introduce practical measures to arrest juror attrition. The amendments will also provide a broader discretion as to who is impanelled and facilitate additional or replacement jurors where appropriate. These changes are welcome as they strengthen the justice system and provide a fairer process for all litigants. The amendments also recognise that modern jurors use email, a very sensible change. However, there is a serious concern with paragraph 8 in Schedule 1 of this bill. This seeks to amend section 55F to cut in half the minimum deliberation time before a majority verdict may be returned. Currently, jurors must deliberate for at least 8 hours before the court is able to consider accepting a majority verdict of 11 of the deadlocked jurors. This 8-hour rule has always been seen as a safeguard because it guaranteed that a majority verdict may be returned only when it was clear that a unanimous verdict was unlikely to be forthcoming after the jury had sufficient time to consider its verdict. In effect, it required the jury to sleep on it before deciding that a unanimous verdict was not possible. Something as serious as personal liberty requires serious consideration, and no clear case has been made for why we should move away from this safeguard. We are opposed to this change and will be supporting an amendment to this bill which will retain this safeguard. This cut in time is a literal shortcut to the criminal justice system and must be opposed. Subject to this amendment being passed, we are happy to support this bill.